Everyday injustice. Too many wrongful convictions. Corruption has infected the criminal justice system, leaving too many people helpless, fighting for their lives. Instead of receiving justice, people suffer. Is that why they say justice is blind?
Hello, and welcome to the Everyday Injustice Podcast. I'm your host, David Greenwald. For the past 10 years, we've operated Vanguard Court Watches in California, including San Francisco, Sacramento, and Yolo counties. Our goal? Expose everyday court injustices, and now, more broadly, shine a spotlight on injustices in the entire criminal justice system, in the form of wrongful convictions, police and prosecutorial misconduct, and mass incarceration. This podcast hopes to take it a step further and highlight criminal justice reform on a national level.
Everyday injustice.
Today on Everyday Injustice, we have UCLA law professor Scott Cummings. Welcome to our show.
Thank you. Thanks for having me.
So we saw this publication that you had co-authored a few years ago on public interest lawyers. And what is exactly public interest law?
Public interest law is a category of legal practice in which lawyers represent underrepresented groups and individuals and provide legal services for free on issues that are really important in society. So classic examples of public interest lawyers are lawyers like the civil rights lawyers that worked for the NAACP back in the 1960s. ACLU lawyers are considered public interest lawyers. Lawyers who represent low-income people for free, legal aid lawyers, are also in the category of public interest lawyers. So we're really talking broadly about lawyers who represent individuals and groups that are unable to access legal services.
And are we seeing a downward trend or an uptick in interest in that kind of law?
I think definitely through the Trump era, there was a tremendous upsurge in interest in this kind of law. I mean, you'll remember in the early days of the Trump administration when Trump administered the Muslim ban, there were lawyers that showed up at airports to try to help people get into the country that were legally entitled to be here. And that really did focus a spotlight on the importance of these public interest lawyers and not only helping people with critical legal issues, but securing the rule of law.
And, in the broader scheme, how big a role do they play in, social justice or transformation of society?
I mean, that's a hard question to answer, I think, in the abstract. If you look at the history of the U.S. And the lawyers working in this public interest space have been really critical in advancing important social movements and building a more inclusive democracy. I mean, I go back to the early years of the civil rights movement and the critical role that Thurgood Marshall and the NAACP legal team played in planting the seeds for Brown versus Board of Education, winning that case, and then really opening up the wider civil rights movement to create inclusion for Black Americans, a project that is still obviously ongoing. But that was, I think, one of the most important and prominent examples of the role that public interest lawyers have played. That movement really spawned the growth of public interest law as a set of organizations and a career path in the 1970s and 1980s. And lawyers in these organizations, again, have collaborated with social movements to really do important things in society. And if you look at social movements throughout American history, like lawyers have been there at every step. And so they're not in the vanguard necessarily, but they're really crucial to ensuring that legal rights are codified and protected over time.
Now, would you consider something like indigent defense, public defenders to be a public interest law area?
Well, bringing it to the article that I wrote with my colleagues, Catherine Alveston and Rick Abel, we do define in that particular piece public interest law broadly. I think people would say accurately that the definition of public interest law and the public interest more broadly is deeply contested. We don't take sides in that contestation, but we do provide a definition that includes lawyers in nonprofit organizations like the ACLU and NAACP, as I've suggested, lawyers who work in legal aid organizations, lawyers who work in government agencies, and also lawyers who work in public defender offices. So for the purposes of our article, we do define public interest broadly to include public defenders, but different kind of people have different views. It's not something that's fixed in stone. And so we also, because we did an empirical study, have the capacity to kind of break out different groups and just look more specifically at the trajectories of lawyers in NGOs, but not public defenders, for example.
So what is your background and how did you get into this particular subject matter?
Well, my background is as a public interest lawyer. I entered practice a long time ago now as a public interest lawyer at a local legal services organization here in Los Angeles. And I did non-litigation public interest law, which was kind of an emerging area at the time. I represented organizations that were trying to build economic opportunity in low-income communities. So I was doing transactional public interest legal work in support of community-based organizations, building housing and providing jobs for low-income people. I came to UCLA in 2002, and very early in my career here, I became deeply involved in our seminal public interest program. It's now called the Epstein Program in Public Interest Law and Policy. And that program is designed to support students who want to have careers in public interest law. It was one of the first, if not the first program in the country to do this. And the idea behind the program is to select students that demonstrate high public interest potential, and then to provide a curriculum that's specifically adapted to training them and helping them network and build profiles to get them jobs once they graduate. And so in many ways, the study that is the basis for the article that we wrote a couple of years ago was motivated by an interest in actually empirically studying whether or not what we were doing in the program, selecting students based on their past public interest experience, was in fact yielding public interest lawyers in practice. So the work that I've done here at UCLA in the public interest field was really the genesis for wanting to know more about lawyers that do this kind of work and how you can best support them in law school.
And so what did you learn?
Well, we learned that law school matters. Law school matters. So we learned what folks coming into law school bring with them in terms of their, what we call in this paper, their endowment, which both includes their background experiences and some of the stuff that they do in college, does in fact shape or relate to the potential for these graduates to do public interest work after they leave law school. But stuff that we do in law school actually also makes a positive contribution to what we in the paper call public interest persistence. So lawyers who enter and stay in public interest law over the long term. So I'm happy to describe what those factors are, but just briefly, one of the sort of the background debates within legal education around public interest law has really been whether or not law school can do a better job, given significant empirical research over a fairly long period of time, really starting in the 1980s, that demonstrated that although large proportions of entering law students, often half or more, expressed the desire to represent underserved clients or causes when they entered law school, the proportion doing so after graduation fell almost to zero, not quite zero, but usually less than 5%. and this gap between kind of entering idealism and the reality of how few graduates actually did public interest law after graduation is an idea called public interest drift. So you're drifting away from your idealism and becoming incorporated into commercial practice and not following your public interest dreams. So that idea of drift is kind of the background operating principle that we launched this study against, and we wanted to see what motivated those graduates to stay in it for good, to be persistent and to not drift away. And again, what we found is that law school does matter, but in some surprising ways.
For instance?
So some of the things that we expected to matter in law school didn't matter that much. So, one of the big curricular innovations in law school over the past 50 years has been the advent of clinical legal education. So having students do hands-on real-world legal work for clients, often low-income clients. And I think we expected that working in a law school clinic might correlate to public interest careers after graduation. And what we found was that that wasn't the case. Taking a law school clinical course was not related to public interest employment after graduation. Another surprising thing was, again, in the kind of negative frame, that we expected that schools that had initiated opportunities for students to do pro bono volunteering, which again has kind of been a big trend over the last 25 years in law school, that students that had engaged in public interest or pro bono volunteering would be more likely to do public interest work over time, given the nature of the pro bono volunteer work, focusing on representing underserved clients. But we found there that it was actually inversely related. So if you volunteered pro bono during law school, it was actually negatively related to holding a current public interest job. And so those were some surprising things around the kind of institutionalization of public service in law schools. Actually, at least in our study, wasn't doing the work of producing public interest lawyers, and we have some speculations as to why that might be so.
Is that a matter of they're getting exposed to the hardships of that kind of work, and they realize that maybe it's a thankless job? I don't know. I'm just speculating.
Yeah, I think our speculation was twofold. One is that with respect to volunteering pro bono, one thought that we had is that pro bono conceptualizes public service work, in some respect at least, as charity. And the kind of charitable frame, right? You do it around your primary work, which is working for paying clients. But that framing around charity actually was inconsistent with the ethos of students who actually want to enter into public interest practice as their full-time career. And so volunteering may instantiate a value of volunteering for lawyers who go into the private sector, but it wasn't really compatible with the spirit and the mission of the students who wanted to go and stay in public interest practice for good on the front lines, working in NGOs or other contexts. And then with clinical courses, I think one of the interesting facets of clinical education in the last, roughly 20 years probably has been that it's expanded quite dramatically away from its original focus on serving indigent clients and instantiating the value of public service and public interest work. Has really become more oriented around, in general, I would say, skills acquisition. There's a term of art called market-ready lawyers, and so clinics are, in some ways, training lawyers to enter into the private sector as well as the public sector. And so it could be that the changing nature of law school clinical education and the broadening of that education to really focus on the private market as well has made it less of a site for incubating public interest practice. The things that did end up mattering, interestingly, were things that one other thing that ended up not mattering that was a little bit surprising before I go to the things that did matter were law school specializations like the one at our law school. And so again, I told you that one of the motivations for studying public interest careers was to determine whether or not our program was having an impact. And what we found was that there was no relationship between having a specialized curriculum focused on public interest law and public interest employment after having gone through one of those specializations and having that predict public interest practice after graduation. And again, that was a little surprising to us, and something that we weren't expecting. However, we also speculated that it was potentially a function of the study, which I haven't talked about the design, but we did look at graduates from 6 California law schools, and only 2 of those law schools during the period that we studied actually had specialization. So the numbers were actually really small of the students who were going through those programs and then graduating and doing work afterwards. And so we may not have actually been picking up the effect essentially of the specialization. The things that did matter were things that were actually outside of the formal curriculum, and this was an interesting finding for us. So engaging in public interest law extracurricular activities, engaging in public interest law externships, and really significantly working in a public interest job during your 2L summer were all activities that were strongly correlated with holding public interest jobs after graduation. And so we kind of theorized based on these kind of outside the formal curriculum activities that what they're bringing to students is this kind of the law schools are facilitating these experiences that are actually giving students the initiative, the understanding of the way that the public interest market works, the drive and the networks to succeed in gaining public interest employment afterwards. And so one of the recommendations from our study is to really invest more heavily in these kinds of activities that are teaching students, allowing students to exercise initiative and understand how public interest job markets work and build the networks necessary for them to be successful.
So that makes sense. And kind of the whole picture, once you describe all that, makes a lot of sense, right? Because they're looking for a career, not a charity. So it makes sense that if they're involved in pro bono work, they may view it more as a charity rather than a career path. Are you surprised though overall that the drift is really as pronounced as it turns out to be, from over 50% down to 5%?
I guess I'm not that surprised, and one of the reasons I'm not surprised, a couple of reasons I'm not surprised that drift is significant. One is that I think if you look at the way that studies of drift define drift, the kind of values that students bring into law school at the first instance are values that lots of people share, and you would expect people going to law school to have on average, which go to some level toward having an impact on society in a generalized sense. And there are students who come into law school and say, my main goal in life is to make a lot of money at a big law firm, but that's really not what attracts, I think, most people to law school. There's something else about being a lawyer and being part of a profession that has a public role that is appealing. But the kind of generality of that idea, I think, doesn't necessarily predict the people who are going to go in very specific types of legal careers that are advancing very specific types of causes, be they civil rights, racial justice, environmental justice, or the like. And so, I think looking at people who come in who have had real concrete experiences in those issues that kind of demonstrate that they're willing to pursue them and commit themselves to it are the more relevant criteria for predicting whether or not they're going to be public interest lawyers after the fact. So I think that the point is that the way that this study sort of look at idealism entering into law school is at a level of generality that doesn't actually tell us a huge amount necessarily about the specific reasons that students are going to pursue public interest during law school and pursue public interest practice after the fact. I mean, the other important element, I think, to that is there is a market constraint, right, in terms of the availability of jobs in the public interest after one graduates is not infinitely expansive. And so even though there are students who might like to pursue public interest law, at the end of the day, they don't all get jobs, at least their first jobs, in the kinds of organizations and entities that they might prefer. One of the interesting things from the study is that the percentage of graduates in the public interest sort of expands over time. So there is a migration from private practice of various sorts into public interest law over time, but the kind of initial constraints on the availability of jobs are also doing some work.
That's interesting as well. Were you able to track like the inclinations over time? Because it seems to me like in the 60s, there were probably a lot of people really interested in going into public interest type law. I know when I was a student in the 80s and early 90s, that a lot of people were really interested in going into corporate law and they wanted to be rich and work on Wall Street. And then it seems like society's kind of shifted again in the last 20, 30 years. Do you have any kind of sense for that?
I don't have any empirical data on that. I think it is an interesting question. There are some, more longitudinal studies on not on sort of more generally on kind of political values and sort of social justice mission. I think if you want to put it that way. That would probably map on to the flow that you described, but we don't, in this particular study, look at attitudes toward public interest or social justice work over time. We do cite the relevant earlier studies that are, kind of all point in time studies in terms of people's attitudes, lawyers' attitudes about this. And, I think there is an understanding, as you just articulated, that the lawyers' attitudes, like people's attitudes more broadly, are shaped by these large scale macro level political and economic changes in society. And we have been in moments like the 60s and 70s when these issues were more salient, and in fact the salience of these issues motivated lots of people to go to law school during that time, and motivated law schools to start to build clinical programs that were designed to be responsive to the demands of students to have socially relevant careers. And government and foundations stepped into the void to really fund opportunities for lawyers to come out of law school and make a difference by having careers in nonprofit organizations that just didn't exist before that period of time. So yeah, demand, I think, based on kind of where society is from a political standpoint, does matter. And I do think we're in another moment when it does matter.
From your perspective then, what has your law school done in response to your study? Has it changed anything yet?
In response to our study, I guess I would say that my school, I feel very lucky that my school has had in place programmatic support that has really been at the cutting edge. And so there are already a lot of pieces that were in place that were, that we've been very happy about and have been really critical to the way that students who want to do this work have experienced law school. So I guess that's a way of saying that there wasn't a huge amount of kind of there wasn't a huge amount of space for large scale change, because so much of the groundwork had already been laid. We have been in interesting conversations because of the findings again around around the kind of non-curricular dimensions mattering, about how to kind of expand opportunities in these regards. And the school has over the past period significantly expanded opportunities for externships during the year. And again, that was one of the factors that did relate significantly to graduates having a public interest job. So that's something that's been happening, and that we've encouraged, based on the findings from our study, to kind of continue to happen, because it does have an impact. And then the other thing that I think is very important that I didn't mention, but has been a focus of conversation and additional investment by the law school, is that mentoring matters a lot in shaping public interest careers. And so one of the strong law school level factors that related to public interest persistence was having a important mentor. It didn't really matter where that mentor was coming from, whether they were a mentor that was on the full-time faculty or an adjunct faculty or a staff member, but having someone who really stepped in to make a difference in encouraging students and helping them gain contacts and and sort of envisioning what that career would look like mattered profoundly. And so one of the things that we have done is try to figure out ways to encourage mentoring and to give credit to faculty and staff who engage in that mentoring, because so often it is considered to be essentially work that is hidden. If it goes under the radar screen, it doesn't get credited in the same way that you get credited for other kinds of work in law schools. And so trying to figure out ways to elevate mentoring and to give it credit and to motivate more people to engage in it, because it does really have a significant impact on students as they try to navigate the maze of law school to get out on the other side to do the work they want.
So your study focused pretty primarily or exclusively, I guess, on California law schools. And you mentioned one of the problems with that was that not all the schools had these kinds of programs, but it seems to me that the other factor is that you're drawing from a population in California, which is at this point a deep blue state. And so, you may see very different results if you look at, Texas or Alabama or somewhere else. What are your thoughts on that?
I think that's a good point. We designed the study in a way that was in some ways trying to control for precisely that kind of variation, in the sense of wanting to compare schools within a regional market, in a regional market where there's a lot of variations in the region, right? The schools that we study were concentrated in LA and the Bay Area, so very different kinds of underlying economic bases and organizational structures for public interest, but wanting to get some traction on a comparison where there'd be a lot of similar factors that would allow us to do some kind of effective control, but then studying different trajectories from schools that were differently positioned, because some were private, some were public, some were differently ranked in terms of their status level in the hierarchy of law school status. Some have different kinds of focuses in terms of their underlying ethos and mission, and to get some traction out of the similarity of the overall market, but also differences within that market. I think the trade-off of that, as you've indicated, is that we do have a particular picture in a particular location during a particular time, and that doesn't necessarily extend to other places in different time frames, particularly in a context in which there is so much economic inequality and political polarization. And so as you move from California to Texas, as in your example, you would expect to see lots of differences in terms of the way that these things play out. So I think one of the things is that we hope that this would be an invitation to other researchers to do similar sorts of studies in different places, and maybe even motivate studies that were nationwide, so you can get some comparative analysis across those dimensions.
And I'll just add this point for the listeners' sake, as a former academic myself, I fully realize that you can't make your study be all things to all people. So, don't take it as a criticism, just kind of a limitation.
Yeah, and it was a limitation. And there's sort of an interesting, if your listeners were interested, interesting, story about how these studies get designed, where you get funding for them, how you have to put them together. That did really lead us to selecting schools within California, because it was the kind of frame that made the most sense in terms of raising funding to get to do important work, but with the kind of right type of scope that would allow you to to execute a project, and to realize interesting findings within a reasonable period of time. So it was an exercise in kind of trying to figure out exactly how to do this in a way that would produce important results without kind of overshooting the mark, and get funding from important national funders. Like the National Science Foundation was a main funder for this study, and that was something that we really worked with them to devise a study that would work out within a time frame and to yield these kinds of results.
And then finally, what's kind of your takeaway? Are you optimistic, pessimistic, kind of in the middle? I mean, where do you see this going at this point?
I'm optimistic in the sense that lots of law schools are following suit. They're making investments. They're driven by competition in the market, but also the demand by students who want to have careers of relevance and conscience. And I do think that the growth of programs and investments in supporting public interest students, a widening of opportunities through extracurricular activities and externships across lots of law schools does make me hopeful that there are opportunities for students to have significant impactful careers and be supported in law school for doing it. So I think law school now, for students that want to pursue public interest work, looks a lot different than law school when I was a student back in the 90s. There's just so much more robust infrastructure, and that makes me optimistic that students who really want this work can be supported and do the work once they graduate. There are still, I think, barriers, but I think those barriers have been reduced and in ways that we have to keep working towards. But I think we're in a much better place, and continuing to work on these kinds of projects and to push law schools to live up to their promise to train students who are going to protect the rule of law and promote equal justice is really, I think, what our collective commitment is.
Well, I want to thank you for coming on and taking the time to share. This is, an important issue that I don't think gets a lot of thought, certainly outside of the law school setting. Very enlightening conversation. So thank you.
Thanks for having me. I really appreciate it.
We've been talking with Scott Cummings. He's a UCLA law professor. We've been talking about public interest law. This is Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.
Thank you to George Powell and Norman Mousequake Barrett for the use of our opening, Everyday Injustice. You can see more of George's music at www.justiceforgeorgepowell.com. That's Justice for George Powell, all one word, .com.